Hi everyone, this week's video is going to focus on the giving of notice, and specifically we're going to look at resignations in the heat of the moment, which can potentially go against the usual rule. The default position is that once a valid notice has been given, it cannot be withdrawn unilaterally by employee or employer. So if, for example, an employee resigns, thinks about it for some time and decides that they don't actually want to leave, there is no concept of somebody being allowed to withdraw that notice and continue working for the company. They will need to either agree that can be revoked with the consent of the employer, or again with consent the notice period can be extended or reduced. Now the exception to that rule is in very limited circumstances you may have a termination in the heat of the moment. So the Employment Appeals Tribunal has said that it is good industrial relations practice to give the opportunity to withdraw words of dismissal or resignation spoken in the heat of the moment after parties have calmed down. Now, the Court of Appeal has identified special circumstances that might allow an unambiguous resignation to be effectively withdrawn. That may relate to, for example, a very immature employee, a decision taken in the heat of the moment, or an employee being jostled into a decision by the employer. So we have a couple of cases to explore that principle of a heat of the moment resignation. Sovereign House and Savage. Whilst generally unambiguous words of resignation would lead to the conclusion that someone's resigned, in some cases there may be something in the context of the exchange or in the circumstances of the employee, him or herself, that would entitle the tribunal to find that there was no real resignation despite what might appear at first sight. Second case, Greater Glasgow Health Board and Mackay. This considered an employee who wrote out a letter of resignation while suffering from a state of anxiety. The rationale in this case was that where possible exceptions to a general rule are suggested, only in exceptional circumstances will this be justified. So it's not the case that everybody who comes back after regretting making a decision to resign will be allowed to essentially retract that, but there are circumstances where that may apply. And in Quickfit and Lynham, the approach that a tribunal suggested should be followed is that a reasonable period of time should be allowed to lapse. If circumstances arise during that period which put the employer on notice that further inquiry is desirable to see whether the resignation was really intended, an employer should not simply ignore that inquiry and would do so at its own risk. The period of time is likely to be relatively short, such as a day or two. And a case which followed the Quickfit matter, Alley and Birmingham City Council, confirmed that special circumstances were held not to exist, so the resignation was confirmed, where the employee had persisted in his desire to resign after being given a 30-minute opportunity to reflect. He tried to withdraw that resignation 4 days later, and the tribunal held that he could not do so because of the unambiguous words, because he was given that period of reflection, and quite a few days had passed before he tried to revoke that. In practice, I've come across cases where I've asked my client to exercise more caution, where, for example, an employee is suffering from mental impairment. They may not be able to make those rational choices, or at least may be relying on that impairment, such as stress and anxiety, when making the decision initially. There may also have been a very significant argument in the workplace. So a manager and employee, for example, may be arguing in a very heated way with each other. Employee walks off site and says, I'm going, I'm leaving, and maybe comes back the morning after and says, I really regret that. The decision was taken in the heat of the moment. Again, I would be saying exercise a lot of caution there about whether to accept or reject that request. I'll just talk as well about fresh dismissals during the notice period. So if an employee has, for example, resigned, they may be giving 3 months' notice. It is possible that a fresh dismissal can take place during that notice period. So if, for example, during notice the employee commits an act of gross misconduct, the employer is entitled to dismiss. It does convert the reason for termination to a dismissal rather than a resignation. It brings forward the termination date depending on whether notice is given or not. And there are various tactical reasons why a business may do that. quite simply, for financial reasons, if there is genuine gross misconduct which is committed, a dismissal would stop any notice payment applying at that time. But what it may also do is limit an employee's ability to bring certain claims. So if an employee with 1 year and 11 months of service resigns on 3 months' notice, the employer might tactically terminate immediately and pay in lieu, or if it finds some gross misconduct, dismiss summarily. The termination date will be brought forward, even if that has the effect of preventing an employee from accruing rights such as unfair dismissal rights, which kick in after 2 years. Finally, on that front, just as a simple reduction of financial liability, some contracts of employment provide for a greater notice period from the employee. So it's not uncommon to find a requirement that an employee, whereas in the first year of employment, the company may be able to dismiss on 1 week's notice. If you find, therefore, that the employee has resigned on 3 months, it is possible to issue a counter notice in accordance with the contract, which could shorten that notice period, bring forward the termination date, and reduce financial liability quite significantly. The only caveat to that, of course, is it does convert the resignation to a dismissal, but if it is in the first 2 years of employment, the employee will not have a right to bring an unfair dismissal claim. So that was a whistle-stop tour of resignations in the heat of the moment. Just be aware that if an employee does hand their notice in, and it's in consequence of an event such as a period of absence, or where there's been a significant issue or incident at work that's led to that decision, which may be in the heat of the moment, there is an obligation to at least consider whether we should be allowing an employee back, taking into account all of the circumstances and cases that we've discussed. If you do need any more assistance on that or any employment matter generally, please do contact us. Visit chadwicklawrence.co.uk or email employmenthub@chadlaw.co.uk. Thank you.